Today on Off the Clock, we're going to chat about the proposed regulations regarding the Pregnant Worker Fairness Act. Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice. So back again to talk about the Pregnant Worker Fairness Act.
Yes, well, we had a very short statute to discuss before.
Yes,
and now we have
right.
a very long regulation.
250 pages or so.
250. Yeah. And if
Yes.
I know you, you read every page.
I did read every page.
The
yes.
rest of us don't have to.
Yes, that's exactly right. That's exactly right.
So, first of all, what does this mean that there are proposed regs?
Right.
Is this the law of the land now? All this 250 pages of
Right.
stuff we now need to...
So it is great. So great question. It is not, these regs are not the law of the land.
Okay.
Okay. The Department of Labor, and this is the way it works whenever a government agency wants to publish regulations. Okay. The rule is that they first have to publish what they call proposed regulations.
Okay.
And then they give the public an opportunity to comment on them and provide input. And then supposedly the agency takes all of that input and uses it to then publish final regulations. Okay?
Okay.
So these are just the proposed regulations right now.
Proposed, okay.
They are not the final regs, and they will not become final for several months until we get through that notice and comment period and they take all of that information and publish them. However, these particular proposed regs have a lot of meat on them, Rebecca, right?
Yes.
And so they really do give us a tremendous amount of insight with regard to how the EEOC is viewing the Pregnant Worker Fairness Act and how they are likely to interpret and enforce the law in the interim, right? Okay. So right now, we have a law that exists and is enforceable. We have employers who are required to comply with that law. Okay.
Okay. I'm tracking you.
And so if an individual files a charge of discrimination with the EEOC can't rely on these proposed regulations, but we know what they're thinking.
Right.
Right? When they get that charge and how they're going to interpret the law and how they're going to interpret what the employer did or did not do.
So if there's a gray area now that an employer is dealing with regarding a pregnant employee
Yes.
and this new act comes into play, and we want to know what the EEOC might be thinking about a position they may take, we may look to the proposed regs in that conversation.
Absolutely, as a frame of reference.
Right, but they can't be cited, an employer can't be cited or can't be alleged to have violated the law for not having followed these proposed regulations.
That's right.
Okay.
Some of the, I will point out, and we'll get into the details, but some of the things in the regs are also in the law, right?
Okay. That's good. That's helpful.
So we do have to follow the law itself, right? But
Right.
then the interpretation of the law is in the regulations.
That is
Okay.
crack legal advice. Follow
Yes.
the law.
Yeah, that's right.
That's why you make the big bucks.
Exactly.
Follow the law,
Exactly.
folks. Okay, so should we get into what the regs actually say?
Yes, because
I think it's
they're
fast.
really quite interesting.
They are very interesting, based on what you told me, because you're the one that read the 250 pages.
Right. We call it interesting. HR folks are going to call it frustrating, I think, a bit.
Oh, okay. So we shouldn't be smiling so much.
No, we should be apologetic.
Serious face. What are the highlights, Sarah?
Yeah. So the broad overall highlight for me that I want everybody to understand is that the accommodation process, standards and process for pregnant employees are different than those under the ADA. Okay? So listeners, business folks, HR folks, hopefully there's a general understanding now that pregnancy falls under the ADA. Okay. I think probably a lot of people then thought, well, that's fine. I'll just apply my reasonable accommodation process that I've developed over time.
Yep.
or generally understand. And I'll just apply that to pregnant workers now as well. So no big deal.
I totally agree with you.
I
That's
am
what people
very
think.
sorry for all of you because that is absolutely not the case.
Wow.
And the reality is that likely you are going to be putting together a different accommodation process for pregnant workers in comparison to employees with other health issues that require accommodation.
How is the process different for pregnant employees?
Okay, so there's a number of ways it's different. The first one, and probably the most important one, is that, and this is true under the law itself, okay, that employees are considered, pregnant workers are considered qualified even if they can't perform their essential job functions for a temporary period of time.
Okay.
The regulations, not surprisingly to you or me or anyone else, have now defined a temporary period of time to be, any guesses? We sort of saw this one coming.
Let's see, how long are people pregnant
40 weeks,
usually?
Rebecca, 40 weeks.
Why
exactly.
didn't they just say that
exactly.
in the statute, by the way? But anyway.
Exactly. So we commonly understand that the ADA normally doesn't require employers to take away essential job functions or forgive somebody's inability to perform essential job functions as an accommodation.
That's right.
Right.
Yep.
I've probably said that 100,000 times. Right.
Yeah, any ADA accommodation issue, that's what we talk about first. So what are the employee's essential job functions?
Yes.
What is the proposed accommodation?
Et cetera.
And do those infringe on the essential job?
So just right out of the gates, for pregnant workers, that's turned completely on its head. As long as the inability to perform essential job functions is 40 weeks or less, that is de facto, that is considered to be reasonable. In other words, that employee is still qualified to do the job. Okay. Now, of course, the employer could still look at whether it's an undue hardship.
Okay. All right.
To
now
provide,
you're giving folks
and
hope.
we'll talk about that in a minute.
Okay.
Okay. But first, just out of the gate, that concept of essential job functions is absolutely turned on its head. And with that, Rebecca, the regulations provide some examples of reasonable accommodations. And one of those examples is light duty and modified work, particularly if a business provides light duty or modified work to others, such as those with work-related injuries.
Okay.
Right? So what the EEOC's regs essentially do, right, big picture for employers, is to say, unless it would be an undue hardship, we are expecting you to find light duty and restricted work for pregnant workers if that's what you need to do to keep them in the workplace.
Wow. That is a huge change.
Yes, that's a sea change.
Yes. Are there any other suggested reasonable accommodations?
Here's another one. Intermittent time off.
Okay, the word intermittent.
Yeah. So
HR folks hate that word,
Yes.
right? Yes, okay. Talk to me more about that and
And
what
this-
that can include.
this sometimes comes up for a pregnant worker who's not eligible for FMLA leave.
Right.
Right? And they're needing to miss work for reasons related to the pregnancy. It usually is only an issue if it's that unpredictable intermittent time off work. If it's simply to go to their appointments,
Yeah.
that generally doesn't become an issue because then they can use their PTO or get that time off to do that. And again, under our usual interpretation of the ADA, reasonable and predictable attendance is an essential job function.
Is in almost every job description
every
we work
job,
on.
but the
and
EEOC
in every job. Yes.
Says employers, if a pregnant worker cannot achieve predictable attendance for 40 weeks or less,
Wow.
that could be something that you have to forgive unless it would be an undue hardship to do that. Okay? So, again, in effect, these regulations are not only requiring employers to provide light duty work to pregnant workers, but also for those pregnant workers who don't qualify for FMLA leave for one reason or another. They are effectively giving those workers the benefits of the FMLA.
And continue along those same lines, continuous leave can also be a reasonable accommodation under this regulation.
But
right?
that's true under the ADA in general
Yeah.
as well. So that's not as much of a difference
Yeah.
between these regs and how we understand the ADA to work.
And then there's others that EEOC says should never really be a problem, although they might in certain settings. But the EEOC says these certain things will almost never be a problem, right? Allowing
Yes.
extra water, right?
Yeah, so the regulations, interestingly, the proposed regs call out a list of accommodations that the EEOC believes are always reasonable.
They use the word always. That's pretty strong language. So before an employer denies these requests for some of the following things, they better think long and hard.
They essentially say that. Now, I disagree. When I tell you what they are, you and I are both going to think of examples where we think it would not be reasonable. So that's not to say that the employer, again, still couldn't try to show undue hardship. But
Right.
the EEOC is saying there's going to be an assumption on our part that this is reasonable, and you are going to have to work very, very hard to convince us otherwise.
What are some of those things?
So there's 4 categories. The first one is allowing an individual to carry water or drink during the workday. Okay. Now, this one is interesting to me because it seems like not an issue until it is. So by that I mean truly, if carrying drink and water during the workday is not a problem, most employers would allow anybody to do it.
Right.
Okay.
Sure.
The only circumstance I can think of in which an employee would say no drink or water for you is if there's a business reason for it.
Exactly.
Right?
Safety issues, right?
Yes.
In healthcare settings,
Yes.
maybe, right? Those sorts.
Yes.
Yeah.
Yes. Safety issues, etc. I know some manufacturing facilities that
yeah.
manufacture sanitary food products and things like that.
Yep.
By FDA standards, employees are not allowed to have food and drink on the production floor, for example.
Interesting.
Right?
Yeah.
So I look at that and I sort of scratch my head because I think, well, the only time that would come up is if it is unreasonable to allow somebody to have food or drink. I don't know a lot of employers who just want to say, no water for you. You are not allowed to have water.
Agree.
The other one is additional bathroom breaks. That's something we talked about during our Lizzo discussion,
Yes.
right?
That's an OSHA issue too, potentially.
Yes,
right.
right. Additional bathroom breaks. The third one is interesting, allowing employees who would otherwise be required to stand during the workday to sit, and then vice versa. Employees who would otherwise be required to sit, letting them stand.
Interesting. That's going to drive some employers crazy who have customer facing, right?
Customer facing and
Cashiers,
manufacturing.
client service, etc. Yeah.
Yep, and manufacturing also. We're going to have some listeners who hear that and are saying, I have some positions on my production line that somebody has to stand for in order to do that job. And then allowing additional breaks as needed to eat or drink. So those are the 4 categories that the EEOC says really are de facto reasonable accommodations, and that employers would have a high burden to prove undue hardship for those.
Another thing that really jumped out at me, the new regulations are documentation.
Yes.
And it jumped out at me because it is so different than our ADA process. Again, kind of drawing the distinctions there. Everyone knows under the ADA, if it's a non-obvious disability, right, you can request documentation from a healthcare provider. What do the regs say?
Yeah, so
about pregnancy?
again, this is why I say your existing ADA process is not plug and play for pregnancy because the rules are different for when you can require documentation and what documentation you can require, okay? So employers under these proposed regs are not allowed to require documentation when the limitation and need for accommodation are obvious, But
Okay.
also if it's for one of the reasons we just talked about, one of those 4 categories.
Okay.
In that case, the only thing we can require is the employee to self-attest to the pregnancy and the need for the accommodation.
So let's just break that. What is who uses the phrase self-attest, right? Other than a bunch of lawyers. So,
Right.
So you can have an employee actually sign a document
And put it
that
in writing.
says, "I am pregnant." If you think there's some shenanigans
Yes.
going on,
Yeah.
right? I would think that not every time you would.
I
do
don't
that.
think it's the fact of the pregnancy that's going to be controversial. I think it's going to be confirming that they need what they're asking for from a medical standpoint.
Yeah. But and again, you can't, just because you can't ask for documentation from a medical provider does not mean you can't have them write it out, or you, right,
Correct.
work with them and have them sign and say if there's any, dishonesty, you may be fired,
Right.
blah, blah, blah. So let's
Right.
separate out what that means when the documentation.
Yeah.
And
And then for circumstances in which employers are allowed to ask for medical documentation to support the pregnancy and or the need for the accommodation.
Right.
Employers cannot use a provider they select. We
So
have to let the employee use a provider they select. So sort of like how the FMLA works.
Yes, so that is a little different.
That is different.
Yes.
That is not how the
Okay.
ADA typically works.
And so that would be appropriate when someone is asking for an accommodation that's not one of those 4, but
Right.
maybe for intermittent leave, for instance.
Yes,
We can ask for documentation in that situation.
we can.
Okay.
We can.
Let's talk about the impact on the business. This is what everyone's been waiting to hear, but don't stop listening after that, folks, because after that we're going to talk about
There's some more surprises.
the definition of pregnancy in the regulations,
Right.
which is fascinating. But before we get to the definition of pregnancy and all that is protected by this new law, let's talk about, don't employers ever get a chance to say, but you don't understand the
Right. We
impact
can't do
this
this
will have
on our
our
business.
on our business.
Right.
When
Right.
do they get that chance?
So essentially for pregnant workers, employers can deny accommodations only if they can demonstrate undue hardship,
Okay.
Rebecca. And the regulations do talk about what undue hardship is.
Okay, good.
They spend most of the time talking about economics and finances, which in my view is not very helpful to most businesses.
We were curious about that when the new law came out.
Right.
Right? Is
Yeah.
it just economics and finances?
Right.
Okay, so that's going to be the leading discussion.
Right. And so there is for very, very small businesses that could be a relevant factor. For mid-size and larger businesses, I'm going to be very honest, most of the accommodations that pregnant employees are likely to request are not going to be things that are so expensive that an organization is going to be able to rely on an undue hardship argument, which means really most of the time we're going to be talking about whether the requested accommodation has an impact on the business's operations, has a significant impact on the operations. And the regulations, when they talk about that, talk about the ability of other employees to perform their own jobs and the facility's ability to conduct business, right? So I see 2 opportunities there,
Okay.
right?
So it is beyond economics. Let's just answer that question.
Yeah.
Because we were curious about that when
Right.
the law came out. Okay.
So I see 2 things here happening, right? If a requested accommodation means that an employee can't perform some of their job
Yeah.
and other employees are going to have to do it for them,
Yeah.
okay? If that would then result in those employees not also being able to do what they're supposed to do, then that could be an undue hardship. You see how you get there?
Yes.
I think that's what the EEOC is talking about with that first part, the ability of other employees to perform their own job duties.
Okay. Got it.
And then, of course, the employer's or the business's ability to just conduct its business. So if we can show the requested accommodation would mean that we can't provide patient care, for example, or we can't supply a customer with the parts that they ordered because of this accommodation, then that could be grounds to show undue hardship.
Can I throw you an FMLA curveball?
Wow.
I know.
Okay.
You do love the FMLA.
This is unplanned. This is unplanned.
You love the
for
FMLA,
record.
but you don't love curveballs.
No, I love.
So this is
What are you talking about?
well, we'll see. All right. I'm anticipating a question on behalf of the employers, and probably this has popped into the heads of some. So folks who are pregnant are often saving up FMLA. Let's just assume the employers, 50 or larger that qualify for the FMLA. Okay. Asking on behalf of them. Pregnant employees often are saving up their FMLA time for after the birth of the child,
Yep.
right? Okay. So now if they need leave, continuous or intermittent, and it's protected leave under this new statute and the regulations, can the employer require them to use FMLA leave to cover those absences?
Great
In other
question.
words, is it an either or between FMLA and these accommodations? And part two, what if an employee says, no, I want it under the accommodation, I don't want it
don't
under
want it
FMLA
to-
because I want all that time after the child arrives?
Great question. So this is assuming the employee is eligible for FMLA
Yes,
leave and has.
assuming that's true, yes.
So the FMLA regulations do support, absolutely do, as does the case law, an employer's ability to designate time off under the FMLA if they know it's for a reason that falls under the FMLA.
Okay.
Right? Employees don't have the ability to say, no, don't designate it. I want to save it for something else.
Got it.
Okay, so
Yep.
I don't believe an employee could play that game, could say, I want time off now as an accommodation under the ADA. Don't count it under the FMLA and let me use it later.
Okay.
However, there's always a however. Oftentimes the reason they want to save their FMLA is because they want to have time off after they give birth.
Yeah, absolutely.
That falls under the ADA now too for pregnant workers. So if we designate time on the front end under the FMLA while they're working before they
Right.
give birth,
Yes.
they exhaust it, and then they give birth, the ADA would require us to provide them continuous leave until they recovered from childbirth.
Right, but the ADA accommodation for leave after birth would be for health or medical reasons,
Yes,
not
not
for
to bond.
bonding.
Correct.
Right, so that's a key difference in ADA and
Yep, you got
okay.
it.
This
Wow,
is
that was deep.
well, I think
Unexpected.
and just to be honest,
Yes.
that just scratched the surface.
Yeah.
Because I think that's where, right,
A lot
the
of
real
this is gonna
issues
happen.
are gonna
Yes, great question.
come in, and is an uncomplicated pregnancy, does that qualify for FMLA anyway, and
Yeah.
what level of complicated?
Right.
So that's the intersection of this new statute and regs and the FMLA, I think is gonna be very interesting.
Very interesting, yeah.
All right, but you just teased out the last part of the statute
Right.
that is just fascinating
Yes.
to me.
Couple
the
of other
definition of
surprises, right.
pregnancy.
Okay, so-
I used to think I knew what being pregnant meant.
Yeah.
I went through fourth grade, right? I had parents who educated me. I've been pregnant. I used to think I knew what it meant until the EEOC taught me I do not know what pregnancy means.
Right.
What does pregnancy mean if you're the EEOC?
Let's talk about the regs have a few other surprises that
okay.
right. So the first surprise is the one that you're mentioning, and that is they very broadly define pregnancy. Mm-hmm. It includes, spoiler alert, not just pregnancy. It includes past pregnancy. It includes childbirth, i.e. the act of becoming not pregnant, right?
I was waiting to see how you were going to describe
Yes.
what childbirth is.
It includes, get this though, it includes
The act of being
miscarriage.
not pregnant.
It includes miscarriage.
Okay.
It includes infertility. And
Infertility treatments?
It says, no, infertility, well, it defines pregnancy to include infertility.
The very opposite
Which
of pregnancy,
means-
frankly.
Yes, and it includes abortion.
Okay.
So
wow.
all of those things fall under the category of pregnancy, which means under the Pregnant Worker Fairness Act, employers are obligated to accommodate an employee with any of those things. So think about infertility for a minute.
Yeah.
Does that mean then that an employee has the right and ability to take intermittent time off work or planned time off work for infertility treatments if they're not eligible for FMLA leave. Yes.
Wow.
Okay,
So we
so
need to
think
broaden
broadly.
our understanding
Yes.
of pregnancy for the purpose of the statute and just think reproduction in general.
Yes.
Right? Things involving reproduction.
That's right.
And when I heard it included infertility, my question to you is, could this cover men?
Could
Right?
this cover
'Cause
men? Right.
face infertility issues as well. Right? And
To which I
sometimes need
scratched
medical
my
care.
head and said, well, I guess it could.
Yeah.
Yeah.
How about that? A man, so this is actually breaking news. I don't know why we haven't seen headlines about this, but according to the EEOC, men can be pregnant.
Wow.
Chew on that.
I feel like, okay.
Infertility is pregnancy.
You're
Under
right
the
about
definition,
that.
men can
Yes.
be infertile, therefore men can be pregnant.
Yeah. Interesting.
See? That's why I went to law school.
Two other quick
all
surprises. This may not be a surprise, more a reminder.
Okay.
This law applies not just to employees, but applicants, people who
Yeah.
a business hasn't hired yet, right? This comes up not infrequently, right? An applicant
Agree.
will show up and obviously are looking to fill a need that the employer has now.
Right. Hence we're hiring.
Very visibly pregnant, right? And the question could be, I've gotten it many times. What do I do with this? I'm trying to hire somebody to fill a role that I need filled now, and this person is not going to be available. So
Now, in the past, we couldn't discriminate based on status of being pregnant, but now we have to make accommodations for that person.
Yeah, exactly. And then finally, this is just a sneaky thing the EEOC did, and I don't know if this will make it through the proposed reg phase, but they snuck in some additional requirements for the Pump Act.
Oh, really?
So, and this really is kind of rankled both of us when we chatted about it, because listeners understand the EEOC does not have jurisdiction over the Pump Act. This is not their otherwise said, this is not their business.
So like legal nerds like us are saying you can't do that.
Our heads are
But
exploding.
you can't do that, right? But the actual substance of it is not.
It's not.
So earth shattering.
If it stays, the regs say additionally, with regard to the space that's required under the Pump Act, it has to be in reasonable proximity to an employee's usual work area. That's a question that's
toughie.
come up for me several times.
That is a toughie in manufacturing settings.
It has to be regularly cleaned.
Good.
It must have electricity, appropriate seating, and a surface sufficient to place a breast pump. Those don't seem to be heavy lifts. But it also has to be in reasonable proximity to a sink, running water, and refrigerator. Those
That's
also
tough.
don't seem like heavy lifts if you're picturing a physical workspace. But for employees who are maybe working construction or on the road or in other places, that is going to be a challenge, should it stay.
I completely agree. So we'll keep folks up to date on that.
So let's just leave our listeners with your thought, Rebecca, your revelation, which is the EEOC has decided that men can be pregnant.
With that, have a good day.
With that, thank you.